Happy New Year. We made it. We are the champions. We made it. And the question is it too early to sue this government? Is it time? 2023, unreasonable delays. How should I do? What can I do? And how should I do it? In this video, we are going to be talking about writ of mandamus, federal lawsuit. Bijou Ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing. And please do not forget to hit the notification bell so you don't miss out on anything in 2023. If you enjoy the content, please go ahead and share, like. Don't forget to comment below. Also join me on Instagram, right? Follow me on Instagram so that we can talk to you about employment base, the options that you have under employment base, the path, the easiest or the fastest path ever is employment base when it comes to immigration. And we talk about all those on Instagram, link in the description box below if you need a consultation. Again, 202-751-2180, email bijou.ngwandaesq@gmail.com. Consultation fees apply. Just remember that when you email me with your questions, I'm just going to send you the consultation link. That's how it works, okay? But you're welcome to comment below and hope that we get to your question and we answer them. Or you can follow me on my private Facebook group where we try to answer questions live if you post them, of course. 2023. Can I sue this government? The answer is yes. Unreasonable delays, you can sue USCIS, you can sue the Department of State, you can sue the consulate. Well, you can sue any agencies involved in the delay. That's the purpose of the mandamus lawsuit. Really, the purpose of it is to force any agency, the government agency, to take action on a case, to really fulfill their duties. They have the responsibility to really communicate with you or fulfill their duties, pretty much work on your petition within a reasonable time. But the question is, what is a reasonable time? Well, reasonable time is what the judge decides is reasonable, okay? And when we see that we have unreasonable delays, we have to sue the USCIS because that's the only way, perhaps, and in my personal opinion, that's the best language that USCIS understand. But the question is, again, will USCIS retaliate? No, that's law. They cannot retaliate once you sue them. But what they can do is provide you with the opportunity, if it's about, let's say, asylum, provide you with the opportunity for the interview, really work on your case and give you the answer whether you, under those circumstances, asylum is warranted. So that's the purpose of suing USCIS. Unreasonable delays. Someone called me and actually wanted to sue, to really sue USCIS. Well, when you come to me with a case, based on unreasonable delays, because those are the reasons why, the only reason why when you sue USCIS, unreasonable delay, not just the only reason, sorry, my mistake. One of the reasons unreasonable delays, abuse of discretionary power, pretty much error in the law, stuff like that. You can sue USCIS. So, but now, when someone comes to me and trying to sue USCIS, that's when we start the assessment. And today I'm going to make an assessment on an asylum case, unreasonable delay. The person filed for asylum in 2014, 15, 16, 17, 18, 19, 20, 21, 22, and this is 2023. So pretty much we're going to say 8 years has passed. So unreasonable when it comes to delays. While the person tried to do expedited requests, but mind you, those expedited requests really, yeah, if you just really want to get some type of solution, just go with the lawsuit, to be honest with you. While expedited requests might work, right? Case by case basis. But the lawsuit, what it does for you is to actually force the government to take action on your case. That's about it. So the person comes and say, well, it has been 8 years, okay? What should I do? I tried expedited request, it didn't work out, so I am ready to file a lawsuit against USCIS. This is how we do the assessment. This is really a particular assessment when it comes to asylum pending with USCIS and unreasonable delays. So the first question is, are you prepared in case your asylum doesn't get granted? Are you prepared to go through those removal proceedings? Are you prepared? Okay. If you've been here for 8 years, of course, we will suggest that you wait at least 2 years if you have qualifying relatives. In case you end up in removal, at that point, you will have a second defense as cancellation of removal, because then you will have 10 years already prior to receiving the notice to appear. But if you don't have qualifying relatives and you don't want to second guess whether the asylum will be granted by the USCIS officer or not, so are you prepared in case it's not granted? Are you prepared to go through removal proceedings? If the answer is yes, then of course we file the lawsuit. Because what the lawsuit will do is to actually force the government to take action on your case. That's it. That's about it. The judge is not going to order USCIS to give you a positive answer. No, the judge is just looking at the facts of the case and decide whether it has been unreasonable for you to wait for 8 years just to get to an interview. And the answer really, obviously, it has been unreasonable. Sometimes USCIS will fight back and say, well, it's not unreasonable, we have backlog, we have this, but 8 years, come on, it is unreasonable, okay? So, assuming that the judge agrees with us and then mandates USCIS to give you the interview, then you go to the interview. We prepare you for your asylum interview, and then we go with you. If you are still in the DC metropolitan area, of course, we go with you. If you're not here, then you have to fly us there, right? So that's how it works. But anyway, we go with you to the interview in question, and remember that the decision that you get from the mandamus lawsuit is not going to influence USCIS in any way. So USCIS still going to go with the merit of the case. So basically, you're going to go through the interview, and once you succeed, yes, of course, asylum is granted. If you're not successful with the interview, your case, we know how it works, the case gets referred back to immigration court. At that point, your asylum becomes defensive, right? If you have qualifying relatives, it helps a lot to really gain some sympathy from the judge. In terms of, let's say, asylum doesn't work, then we can go with withholding of removal. So if you have those other circumstantial evidence, so it really does help with the asylum application when it comes to it being a defensive asylum in court. So that's why we have to prepare you in that way and tell you, okay, this is how the lawsuit works. Lawsuit is just giving you the opportunity, right, to get this government to give you some type of resolution. That's it. But it's not going to provide you with a positive answer in terms of giving you the actual asylum. Asylum is still going to be assessed to merit. You have to be able to go to the interview and actually be successful, convince USCIS as far as fear of persecution is concerned. And then if you convince USCIS, yes, then the asylum will be granted. Then yes, you get a resolution. If not, then the asylum case gets referred to immigration judge. Then we're going to defend it there too. That becomes a separate agreement. So you have to be prepared, and that's our job, to prepare you, to assess your case, to see if you are preparing in case asylum doesn't work for you. What are you going to do? The defenses and stuff like that. That's our job. But what I wanted to say, the message here is clear, right? It's simple. Delays, what can I do? Well, you can file a lawsuit, okay? Unreasonable delay. What is unreasonable delay? What the judge decide. When the judge sees that it is unreasonable, then it is unreasonable. Then USCIS, Department of State, or consulate, they will have a mandate to actually call you for that interview, to resolve your case, in other words. That's it. Happy New Year, folks. We are going to come back with the same problem and providing solutions, especially this year. We're going to talk about those mandamus lawsuit. We're going to talk about 221G administrative processing. We're going to talk about delays at the consulate, Department of State, USCIS, you name it. We are going to find a way, one way or another, get you to that resolution. If you do not have a plan, again, to 2751-2180, okay? Consultation fees apply. This is 2023. You have to take actions. If you do not take actions, nothing will change, because remember, we have been waiting for that reform since 2020, right? When Biden came to power. So we don't want to go to that path. We just want to come with a plan, with a solution. Okay? So until next time, bye-bye. Happy New Year again. This is the new year. We have to be mindful of our plan. We have to be mindful of our decisions. Just don't let immigration be something that you cannot handle. We're here to help. Until next time, bye-bye.